and you have witnesses from the Senate Economic Development, Housing and General Affairs. It is the most beautiful Monday morning we've had in a while. And it is the 8th of May. And we have many things to do in a very short period of time. We are meeting about S100, but because there are some changes in S103 in the House, and our time is running very short, we're just going to hear a bit about some of the proposed changes, which if we don't concur with them, anyway, it's a bit of a challenge at the moment, given how late it is. So, Damien, would you let's start with the quick changes in 103 and then let's pivot to your changes in S100, if we could.
Sure.
Thank you. And we have that at some point.
Okay. Yeah. For the record, Damien Leonard, Legislative Counsel. So the changes in S103, you have a side-by-side in front of you.
Our discrimination, though. Yeah.
Yep. Which should be posted to the web. The primary change is, as it passed this chamber, the equal pay protections were on the basis of sex, race, national origin, and disability. The House is proposing to extend that to all protected characteristics. So sex, race, color, religion, ancestry, national origin, sexual orientation, gender identity, place of birth, crime victim status, age, and disability.
So let's pause there. Let's pause there because I just want to say I've communicated back to them that it's really hard to swallow a huge change like that without it being evidence-based. So we have communicated that back to the House. So I don't want us to get lost in like, what does that mean right now? Because I hope people don't mind. I've already just said, like, we had a really narrow discussion on racial equal pay, and adding every single type of protected class feels like they each need their own consideration. So that was where over the weekend they previewed for us. They were talking about LGBTQIA community folks, which seems to have evidence, and they talk specifically about that, but adding everyone in, religion, et cetera, felt like a new burden on our businesses without much discussion.
Right. Sorry, I hadn't appreciated it was everybody thing. It was represented, but it was based on their initial inclusion of everybody else.
Right.
And then they were adding LGBT. Got it.
Yeah.
So I was thinking it was just going to be, okay, got it.
This is too broad a group.
Yep. I said, I think our committee members will feel that way.
I think you're absolutely right.
Yeah.
I'm particularly concerned about the mental condition issue.
Right.
I think that would just deserve discussion.
So you passed physical or mental condition. That's
We've passed
disability.
We've done a lot of things that are wrong in the past.
So I mean that's disability. So that's paying someone
but,
differently because you become aware that
they
suffer from OCD or something like that.
Right.
So,
but the question is what kind of mental condition would be.
So to qualify as a disability, a mental condition needs to limit a major life activity. So eating, sleeping, breathing, writing, thinking, working.
I don't recall taking any testimony on that issue at all for us to have a good understanding. For example, the guy who screams on the subway, is that a mental condition that's disqualifying?
Well, so to be very clear, in order to be hired for the job, you have to be what's known as a qualified individual with a disability, meaning that you can perform the essential functions of the job with or without a reasonable accommodation. So if your job is one where your mental condition prevents you from performing the functions of the job, then you're not even entitled to the job. So that's an important thing to keep in mind. The ADA does not require you to hire someone whose current disability would prevent them from, for example, working for, performing the work that's required, whether it's, writing grant proposals or whatever it is. But if with a reasonable accommodation, they can perform the functions of the job and they're performing the same job as someone else, they're entitled to equal pay with the other person, assuming there's no seniority or other merit or similar difference.
How about if you could only produce 2/3 of what somebody else
Then you're not
can?
performing the same job,
The
Senator.
same job, okay.
So, yeah,
What if you have a mental condition that is disruptive to the workplace? I assume that that would be disqualifying?
assuming that you can't find a way with a reasonable accommodation to eliminate the disruption, then you have an argument that they're not a qualified individual with a disability. So the reasonable accommodation conversation is complicated. It looks at your resources. It looks at, so for example, if the job requires in-person work, and the reasonable accommodation would be that this person cannot work in person because of the nature of their disability, whatever it is, then very likely at that point, they wouldn't be a qualified individual with disability, assuming that you could only perform the essential functions of the job in person. If it's something like, for example, well, let's take a job as an attorney. There are many attorney jobs where, in fact, there are a number of Vermont attorneys who practice entirely remotely. So that's a job where, for example, if you were, your disability caused you to not be able to come into the office for whatever reason, you could perform that job. On the other hand, if your job were loading trucks and unloading trucks at a warehouse facility, and your disability prevented you from coming into the facility, then you wouldn't be qualified for that job. So
is this language in existence in any other state that you're aware of?
The equal pay language?
Yeah, in terms of the specificity of the characteristics that are included in it.
I would have to look. I don't know.
I just wonder, if anybody's had the experience with this kind of language elsewhere to tell us whether or not there are issues with whether it works well or not.
I would have to look at that.
I do want to make sure to note that some of the people who testified from the day we spent with AFL-CIO and labor folks specifically did testify to this experience. That's the day we heard firsthand testimony from people who felt like they were not told that their performance was suffering, but felt they experienced a lack of promotion and then dismissal because of their mental condition.
So at the moment, the House has taken quite a bit of time with this. I mean, and there are two proposals to change. One is to include all protected classes in number 7, and
so the other is a clarification, really more of a technical change in subdivision J, which you'll find on page 3 of your side-by-side. And this is something that was pointed out by Karen Stackpole from Paul Franken Collins, who's primarily an employer side attorney, although she does represent employees too. And then Julio Thompson and Boryang both concurred in this. And that's that we had left out disparate impact discrimination. So an example of that is it's a facially neutral policy that discriminates against a group as when it's actually applied. So a good example of that is a parcel company had a requirement that they had a policy that if you were on workers' comp and required light duty work, you would get it. However, if you had another disability that required light duty work, you wouldn't get it. And they had a woman on staff who was given a lifting restriction by her doctor late in her pregnancy. And they sent her home on unpaid leave instead of giving her light duty work when she requested it. that was found to be disparate impact discrimination. So the policy was facially neutral, applied to men and women, but because it specifically excluded women who were pregnant and would have the same restrictions, they found that that was disparate impact discrimination. So that was something, what this section says is you're not required to demonstrate the existence of another employee or individual except for equal pay or disparate impact, because you can't make those cases without demonstrating the existence of another individual who's being treated differently. So
Can I pause and ask a process question? Because I don't want to misspeak, but they have not voted on this yet. Is that right, Damien?
No.
Like, you're representing the discussion and some of the language that's been proposed, but have they voted on this
So-
language?
Yes. So the status in the House is complicated.
Okay.
House General passed this bill out 11-1
Oh yeah, they have 12 members.
with the education pieces in it. It went to education, became clear that the education discussion was going to take much longer than we had this session.
And was not really the same. It was sort of apples and oranges. So they pulled it out, right?
What they did is they recommitted the bill to House General, which basically negates former action. They have already voted this language out 11-1. All the language you see highlighted. So the discussion at this point is whether they concur or whether they send the amendment over. And a lot of that's going to depend on whether the Senate feels it can concur in the amendment, or if they concur, it just goes to the governor because they concur with the Senate's proposal.
Right.
So this is a technical change here.
This is a technical change.
The
but
other one is a more significant
Yeah.
change.
Right.
The
Okay.
other piece with the other one that is being discussed today is with the privacy protections that you see at the bottom of page 2 and the top of page 3. Nothing in this section shall be construed to diminish an employee's right to privacy. Emily Adams from the Attorney General's office, as she was reading through this, realized that you don't necessarily have an express right to privacy in things like your gender identity or sexual orientation. So the intent there with the new language, there's proposed new language that would say nothing in this section shall be construed to permit an employer to inquire about a protected characteristic that's not otherwise known to the employer. So for example, your employer may know about these protected characteristics because you've disclosed them because they're facially apparent. But if the employer doesn't otherwise know, they can't send out a questionnaire that says, okay, everyone, I need you to tell me your sexual orientation, your gender identity, your national origin, your place of birth, whether you've ever been the victim of a crime. These are all things that may not be facially apparent. Or your religion, for example.
Can they ask you your pronouns?
So you, right now, with all of this stuff, you can be asked to disclose it optionally. If you wish to, you can disclose it. And that's what would basically stay this way. So right now, your employer can have these demographic surveys where they say, it's up to you if you fill this out. For example, there's always, so the EEOC collects data on things like race, sex, etc. And so there are always these surveys when you hire people which have optional disclosure, but you can choose, I don't wish to disclose. So what's your race? And you could say, you could pick one of the standard EEOC categories, or you could say other, or you could say, no, thank you. And that's where things would stay. Your employer couldn't require you to disclose this.
Right.
So that's really the difference.
Could they require or request with an optional answer any of these categories? beyond that?
They
All of
could,
them?
they could request them with an optional answer
Mhm.
for purposes of, their demographic data to show that they're a diverse workplace, et cetera. But they couldn't require. That's really the difference, is they can't. So the,
So where are we? I'm gonna lose people in 11 minutes. And I think we need to give them a green light on something, on whatever we all can agree to, or we can address some of these additional issues next year. We can. And
I'm just trying to figure out. You can't discriminate against someone on any of this list beyond the protected class list.
right. So this is the full list of protected
I was gonna
classes
say,
for
this is-
discrimination.
Right.
So the difference between an equal pay claim and a discrimination claim is an equal pay claim says, all things being equal between the employees. So let's say same job, same responsibilities, same seniority, same merit, et cetera. You have to pay them equally. If there is a difference in pay, that's a claim by itself. And you're liable for if it's unintentional, you're liable to make up the difference in wages. If it's intentional, you're liable for double the difference as a penalty. Proving the intent is extremely difficult. So typically the way these cases resolve is as soon as the employer becomes aware of it, they correct the difference and the case goes away.
the discrimination.
For discrimination, you need to show the pay differences could be part of a larger discrimination claim, but by themselves, they're not necessarily evidence of discrimination. So that's the difference. Equal pay is a very sort of strict, we're just looking at the numbers and looking at the qualifications. And if we say these two people are equal, then there's an issue. And so this is why a few years ago, when we did a review of pay here at the General Assembly, there were a bunch of adjustments made because they found that over the years with discretionary and merit raises, depending on the year's budget, people had gotten out of line. And so they quickly trued everyone up once they did a review and found that, attorneys who were, say, all had 6 years of experience, there was a $2,000 pay range for an annual pay. And so they made sure everyone trued up to the top pay range. And that's the way equal pay works. Proving discrimination there, the equal pay could have been part of the evidence of discrimination, but you would have had to have a bigger case. That's the difference. So by adding these to equal pay, you're adding that sort of, it's almost a strict sort of, are you paying them equally? And if not, you need to true them up.
Okay.
So that's what that is. It's certainly, I can't have a position on this. It is certainly possible to address these additional pieces next year.
Yes.
And just focus on adding the disparate impact piece. So
Yeah.
The disparate impact piece could even be added next year. Right now, though, that's more of a glaring technical error in the law.
Right.
This is a policy choice. So, and I can't tell you which way to come down on it, but this is more of a policy choice. The disparate impact piece is a gap that it's
a meaningful gap.
It's a meaningful gap
That is what
within
I
the
would say.
policy choice you've already made. So that's, I think, the best way to phrase it.
I would propose that at this point, I mean, if they haven't even passed it out of committee, it's not even on notice, it's not going to get to us to concur until Wednesday or Thursday, right, Keisha? Right, is that sort of,
Depends on rule suspensions.
right, and I think
So
without,
it won't be up on the floor until tomorrow at the earliest.
yeah, if they can get a rule suspension to take it off the notice calendar.
Big questions all around.
Yeah, and I don't know what the House is doing about those at the moment. Randy, are you at all aware what are the rule suspension
Depends on,
inclination is?
it depends on what it is.
Okay, no, I
Right.
was thinking in the House.
Right, on the house, I
So-
don't know.
My feeling on this is more substantial than I had thought. I thought this was more modest than, and I think you could tell that in my emails, Keisha.
Right,
that
yeah, no,
I-
I did, this is a
I had
lot.
not, yeah, I
Yeah.
hadn't quite realized they'd already added all this, so that their request add, so I
Right.
apologize. My context wasn't as full a picture as I think, I would suggest at this point, that we review this work again next year, but that we pass this as is with this one technical change. Because this is a meaningful gap, that is a technical change, and it's based on policy we've already passed, and I would keep the bill as we passed it. And I hate to say this. Do you,
Yeah.
Keisha, do you feel differently? Do you think we can
I
handle this?
agree. I just tried to communicate to Tom because I know, I mean, I don't even think they're meeting today. They were gonna try and circle up or
We
I
are.
think they are.
Yeah,
Um,
they are meeting this afternoon.
Okay.
They're meeting
Okay.
after the floor, I think.
Great.
They're- the
Okay.
fourth One.
I'm scheduled for several hours in
Oh,
South
good.
Central today.
So
Yeah.
then I,
Beginning at what hour?
After the floor, I think, for the committee.
Right,
before
so
the floor
their
for
floor time is
working on
1 o'clock.
Yeah.
So I would suggest that we, at this point, given the time frame, we want this discrimination bill to get over the line, at least to start. We know we have to, that the education group in the House is interested in addressing further aspects of discrimination in schools. I think that we let this go until next year. It's only going to be like a 6-month difference in terms of
right. I just want to make
else?
sure, Senator Clarkson, do we have confirmation of another vehicle for apprenticeship?
I'm dealing with, I've already been working on this with approach. We're getting a rule suspension, I hope in.
Okay,
I
so
mean,
we don't
we're
need-
getting it out of Senate rules. I'll be making a case for it. Randy and I, we've heard about the apprenticeship proposals.
Okay.
I had tried to get it into the budget because it really is just, it brings us into compliance with the feds, and it enables us to draw down more federal dollars. Those were compelling reasons for Jane to consider putting it in the budget. However, they have voted it out. It will make it, if we get Senate rules to let it out of Senate rules. This is the apprenticeship thing we heard about from Cam. And if we can do rule suspension, I don't even think we need a rule suspension. I think we could just vote on it and get it to the governor, concur and get it to the governor.
Great.
So
So
those are the things we
that-
heard.
I just wanted to make sure that was taken care of somewhere else. The
We're
two
Jane
changes,
and I've been back and forth this weekend about it, and I think she was feeling it was so big, even though it complemented the work that's in the budget already on workforce. She felt if we could, we should try and just move it on its own.
right? The two changes, and there's some technical ones maybe that I've missed, but the two big changes that I'll just say I personally could live with if they can accomplish it on that side. But I would really be open to the rest of the committee.
Which bill are you
Is
talking about? 'Cause that bill's less
103.
than half. That's already gone.
103.
she said. Are you talking
So-
103?
Yeah, knowing that we don't need to put apprenticeship there. The other two things that
Right.
have been on my mind are the LGBTQIA protections, because there is some evidence that there's an equal pay issue there, and the striking the education language so we can be silent on it this year and take it up next year, only because the intent of that language for me was to recognize it's not our jurisdiction. Senator Campion and his committee are interested in looking at that issue. So the message I got from the advocates was they would prefer we're silent on it rather than have that sentence in there saying this doesn't apply.
That creates a legal problem.
I know,
How does it
like,
create-
right.
Okay, what sentence are we talking? We're talking about D at the bottom of page,
And I've gotta go.
and Anne's
So
gotta
we're
go.
talking about, D at the bottom of page 6 on
Yeah.
page 7. the provisions of this subdivision 12 shall not apply to any action brought
Under this chapter pursuant
pursuant
to
to
the provision.
16 VSA 570F.
And I'll
The
just say their
problem-
attitude is that it would create uncertainty for 6 months and we can deal with it next year. I hear what our ledge council is saying, so I know we're running out of time. Those are the two changes that I felt if the House was already thinking those would be narrow things that they might do. They might not do either of them. So those are just the two I could live with, but I think the others just don't have enough time for consideration. So I just want to say that, and
Well,
so people
we
know where
need
I
to
stand.
communicate this. Yeah. Okay, committee, how do you feel?
Next
So-
year.
Next year,
So are you okay with the technical change the AG's asked
Yes.
for?
that's fine.
If that means the bill, like if they decide instead to just concur and send it to the governor, it sounds like we're also okay with that. If they don't do the small technical change and send it back to us. Is that true?
Deferred impact, the committee's okay with, or concurrence, obviously, because you already passed.
Right.
It would just be agreeing. Am I hearing anything beyond that? I'm not clear on where the committee's at on the protected categories. It seems like some members are comfortable with adding a couple, but not all. Others would prefer to wait till next year.
Right. I'm comfortable adding LGBTQ to the equal pay, but I also understand we have not taken any testimony
Right.
on adding anything at this point. And except for a technical change from the AG's represented by our own attorney, who is recommending that we do that. So I think, Keisha, at this point, given we have 5 days and
Mhm.
we have only an hour each morning, and we don't even have an hour tomorrow morning, unless people are willing to come in and give us half an hour before the floor.
Floor's at 9:30 tomorrow. Oh,
Yes.
that's right.
We're back to
that-
Tuesday.
We're back to regular Tuesday.
Yeah,
Why?
regular Tuesday. So I,
I have a 9 o'clock. meeting.
yeah, and Randy won't even be with us at 9
Okay.
tomorrow morning. So I think we're gonna have to do 8:30 on Wednesday. We're not gonna have this. So I just think our time frame is such that we need to concur with that they would, the two choices are either concur as is and we'll deal with everything else next year, or concur with the one technical
Right.
change. And we would then concur and send it to the governor.
Yes. That sounds good.
Keisha, are you okay with that? I know
Yeah,
it's
I
less
mean,
than we would.
Yeah, I think the number one question on the table for them is concurring without any change, just because, and frankly, as folks may remember, our committee was somewhat responsible for some of these changes not making it in time last year, that we, the other pieces of the bill that aren't under heavy contention. And I would hate to see those die because of a timing issue again. So.
I couldn't agree more fully. So Damien, are you okay with that, to carry that? And I will call,
So-
Keisha and I will connect with the members on the on their committee that have been talking to us. We'll try anyway.
I don't know how long we're on the floor. I have to go get the bottle bill out.
Yeah,
They
no, I
have-
understand.
But I got 2 other members of my committee.
Okay, I just need to ask you all about S100, because we still need to hear from Damien and David about the other pieces in S100. It is on the floor today, I believe, in the House. Is that right?
Great question. I'm not
Keisha,
sure
what do
off
you
the
want?
top
I've
of my
heard
head,
that.
But
Scott, is that right? Is it on the calendar?
I'm pulling
For
up the
action?
calendar right now. Yes, it's on the calendar for action with just 6 amendments.
Just 6, okay. So we need to figure out when we are meeting to look at those.
Yeah,
And to
80
see what
pages.
actually passes. Of course, we don't know what will actually pass of those 6 amendments. So, anyway, I'm gonna put that bee in our bonnet that we have to figure out when to make
What's
time.
going on at noon today?
We could meet, I'm happy to meet from 12 to 1 if people are willing to
Well,
make the
the
time and
floor,
bring
but
their
I-
lunch.
Yeah,
If
I
you could
think
bring your lunch in here.
I'm not planning on finance till 1:30, so That
Okay,
would,
Great.
I don't think I have another meeting.
okay. I could do that. I know I have one with GovOps, but,
I gotta go.
okay, you go.
Yeah, I really
Okay.
want to be there too.
Yeah, no, I know you do. Keisha,
Okay.
what's your thinking? Is that okay with you to join us?
That's great. Yeah, I think we need to.
I'll only be here from
When
12:30
when
to
is
1.
their floor? Do we know if any of those amendments will?
One.
Okay.
Their
Okay. So
floors
we
at
won't know
one.
yet. Okay.
Damien, can,
This is notes.
could we see David Hall at 12? So Damien, could we see you at 12:30?
Sure.
Keisha, let's you and, okay, we're gonna be on the floor. And you're now supposed to be in finance on the bottle bill.
Yes.
And I know they need you.
Right.
I will try and communicate with, let's just email and text Tom.
Perfect.
And
Perfect.
let him know, and Damien will carry our message. I just think we've run out of time on this, and they're a passionate policy group, I know.
Yeah.
I mean, we are, but,
It's late.
I
It's late in
think
the
we've kinda
session.
Run out of,
Yeah.
what?
It's late in the
It's
session.
called-
Yeah. If you
think
have
the
time to
perfect-
run down and tell the pro tem's office, that sounds good because I'll be in finance and can't be helpful for a little while. So, and then I have a pediatric surgery appointment, nothing's wrong. She just had originally fractured her
I know, it's
tibia,
for
so they're just
tibia.
checking on it. Yeah. So
So you aren't able to join us at 12?
no, 12 is fine.
What-
12 is fine.
Okay, it's just the 1 o'clock, anything after 1 is challenging.
Yeah, it's various times, but
Okay.
yeah.
I think
Text me.
we're clear.
Okay.
I think,
Great.
this is a perfect segue to, this is what we do. We don't always get it perfect the first time,
Right.
and then we come back and keep working on it.
Right.
So, okay, I think with
Okay.
that, we should probably go off live, given we've lost our